Good afternoon. Happy Monday. So, I learned from the comment section from Lane Myers supporters a couple things that I thought was really interesting. Number one, apparently you can't commit a crime against a public employee. And this is news to me. I never realized that there were exceptions in the law for committing crimes against public employees, or the impossibility thereof. But apparently it's true, because Lane Myers supporters, in their infinite wisdom, seem to believe so. Just because you work for a state university does not mean that you can't have crimes committed against you and that people who commit said crimes can't be prosecuted. There is nothing in the codes, in the case law, in the Constitution that prevents the state from criminalizing harassment and or stalking against public employees. There is nothing. No thing. There are some protections for criticism leveled against police officers, but you can, in fact, be charged with and convicted of stalking and harassing police officers. Believe it or not. There's a difference between criticism and harassment. There is a difference between criticism and stalking. And if you don't know the difference, well, then you might just end up locked up like Lane Myers. Another thing that I learned is that all the charges and everything against Lane are bunk, because the prosecutor lied at the grand jury. Told the grand jury that Lane Myers used to date the victim, or something along those lines. Don't really know, don't really care. There is such a thing as a material fact and a non-material fact. If Lane Myers had been charged with domestic violence, i.e. harassment with the DV tag, as they have in Arizona, or stalking with the DV tag, as they have in Arizona, well, then maybe that would be relevant, but he wasn't. So that is not a material fact. So even if that was erroneously introduced by the prosecution, well, it's not material. But beyond that, Lane Myers pled guilty. I don't know how many times I have to say it to Lane Myers' retarded supporters, but any defense that Lane Myers had along those lines or along any other lines, such as the sufficiency of the evidence, the validity of the charges themselves, anything, he waived when he pled guilty to 2 counts, to 2 felonies, a level 5 and a level 6 felony. Pretty low level. Should be handled with probation. Probably won't be, because Lane Myers is a retard. But he gave up all that stuff. Essentially, he said, yup, I did it. He didn't essentially say it. He actually said, yup, I did it. I listened to somebody's stream of the hearing where Lane Myers pled guilty, and the prosecutor laid out facts, specific facts for the 2 counts that he was pleading guilty to. And at the end of it, Lane Myers said, yeah, I'm guilty. So whatever arguments you make about Lane Myers not being guilty, or the charges being spurious, or the prosecution being terrible, horrible, bad people who lie like liar McLiersons, is all moot. It's all gone. Like the water that's trickling through my ditch right now. Here today, gone tomorrow. Except those defenses were, in theory, valid until he pled guilty, and now they're gone. There was a post on my Discord. Apparently somebody is trying to organize a call flood campaign for Lane Myers' attorney. To call flood Lane Myers' attorney. The allegation is that there's a motion that has to be filed today. How any of Lane Myers' retarded supporters would know what needs to be filed today or not is beyond me. I have no idea what needs to be filed today, but I do know that if I was Lane Myers' attorney and I was trying to get something filed today, having a dozen dumbasses call me to tell me how to practice the law while I should be working on preparing and filing said motion would be really fucking annoying. It would eat into my time to prepare the motion that needed to be filed. And I would wonder why all these fucking idiots think they're representing Lane Myers, and why I owe them any duties at all, and why I need to take their phone calls, and why I need to listen to their fucking dumbass legal analysis. Pardon the French. I'm just so tired of stupid people who don't know shit from fuck about the law pretending like they do because they listened to Lane Myers, who also doesn't know shit from fuck about the law. Can a broken clock be right? Sure, twice a day, apparently. But that doesn't mean that you predict that you're going to get a good answer from the broken clock. I read the minutes from the last hearing. It does appear that they did, in fact, for reasons unbeknownst to me, probably because of the fact that Lane Myers already had his attorney with him. Resnick showed up for the hearing, who the court then assigned to Lane Myers for all purposes. Normally, the initial appearance is where the court will give you a public defender. At least that's my experience, generally speaking, from watching some arraignments and initial appearances in Arizona. I was looking at them to see if Lane Myers had made his initial appearance on the 9th or 10th, and he had not. So they combined the initial appearance with the arraignment. The arraignment has to be done no later than 7 days after the initial appearance, and immediately following is within 7 days after the initial appearance. So I guess it all checks out. Now, they're supposed to have their probation revocation hearing no later than 20 days after the arraignment. But the defendant or the defendant's attorney can push that out. And that's exactly what Resnick did. Now, for those of you Lane Myers supporters who think Resnick's a terrible person, you got to remember that there are how many hours per video and how many videos that he's going to have to go through. Also, he has to wait to get the, I guess they requested all of the internal communications by the probation department about Myers. And so, the court gets to review them in camera before anybody else gets them. So there's going to be, delays on getting, theoretically, what could be evidence. So it makes perfect sense that the defense attorney would want 30 days to prepare. That makes perfect sense. It's not some slight against Myers. Oh, my freedom's on the line. Yeah, but if you actually give your attorney the opportunity to prepare and actually go through the materials, etc., you have a better chance of prevailing. So you might not get your hearing faster, but you might actually have a better chance of prevailing at your hearing. So how about you give the fella the time he needs to prepare an adequate defense for Lane Myers? Is that a novel concept? Christ, people are stupid. And I apologize for taking Jesus' name in vain. I'm just frustrated with all of this nonsense. And then Lane's position that his motion had to come first because his motion might make the probation revocation moot. I don't see how that works. And maybe some of Lane's legal scholars can fill me in. So a court order is in effect until either it expires by operation of law, like if the court order says you can't do X, Y, or Z until this date, well, then once that date passes, that order is expired, or subsequent order of the court. Now, the court, as of yet, has not relaxed Lane Myers' probation conditions. And the court may. I mean, Lane may have some stellar argument, or Resnick may have some stellar argument as to why Lane Myers should get to do something. Like, for example, I could see a coherent argument why Lane should be able to report on, like, for example, there's a Supreme Court thing that the husband of the victim was doing, trying to, I think, restrict filming or something like that. And I don't personally see why Lane couldn't report on that as long as he didn't mention, the victim's husband, who is a protected party under the criminal protective order. So I could see where Lane Myers might get a little bit extra. I could see how a good attorney with a good argument, who's had opportunity to prepare, might be able to make a good argument why some of these probation restrictions are overly strict and they go beyond the nexus with the crime and the protection of the victim and the decreased chance of recidivism, repetition of the crime. But even if at the upcoming revocation or the modification hearing, which is I think on like August 8th or something like that, 7th, 8th, somewhere in there, the modification would become the order of the court at the time of the hearing, not at the time that Lane Myers might have previously violated the terms and conditions of his probation. So I don't really know how this is going to help him. The question on the probation revocation hearing is, what were the terms at the time Lane did the action? Or did Lane do the action, and what were the terms and conditions, and was it a violation? So I don't see how him prevailing on his modification hearing, even assuming that he can, would change anything. And, I also can't see how the court is going to, on law in motion, change the terms and conditions of the probation. I don't see how he would change that on law in motion, especially when there are pending allegations that Lane Myers violated the terms and conditions of probation. I think what the court is going to be looking at, since Lane Myers raised First Amendment issues, constitutional issues, I think what the court's going to be looking at is what argument Lane can have to support his motion for modification. Because if Lane does come up with some stellar argument that the terms and conditions violated the First Amendment, which I don't think he will, but in theory he could, then, violating the terms of violating probation terms that are violative of his First Amendment rights, I guess in theory that could work. Maybe that's Lane's tact. I don't know. It's hard to read the mind of a retard. Anyway, that's all I got for you today. Thanks for watching. Hope you enjoyed the sound of my ditch, my berry infested ditch. Can you see it? All right. Anyway, thanks for watching. Have a great day.